Good afternoon, everyone, and welcome. My name is Somalit Hogan with the Small Business Development Center. Thank you for joining us today. Today, we'll be talking about employee laws or employment laws, really, that affect all businesses and every business owners must know about. And this is part of a seminar. This seminar is part of a series of seminars for fundamentals for running a successful business that we've been running during the month of April and May this year. And it is co-hosted by several organizations here in the Valley, including the Western Mass Means Business Collaboration, which is comprised of SCORE, the Center for Women Enterprise, Valley Community Development, Common Capital, and also Franklin County CDC in the Massachusetts Small Business Development Center, which has offices at UMass, at Salem State, and Clark University. And of course, we want to thank our sponsors and funders of these programs that support these webinars for you, the Small Business Administration and the state of Massachusetts. On the screen, you see a list of contact information for folks in these various organizations that you can contact for assistance for your business. Also, if you have any questions about, some of the information that you hear about today, you can certainly follow up with the speakers. I'm sure they'll be posting their contact information. But if you need further assistance with your business, you might want to reach out to the Small Business Development Center closest to you, and you can find that out on the website msbdc.org. The first step to get an appointment with a business advisor is to fill out a request for counseling form. So keep that in mind. You'll have to do that online before you get an appointment. And then now I'd like to share with you real quick, this is the schedule for our series. Today is April 27th, and we're talking again about employment laws. And next week, we'll have Katisha Galishaw talking about how to manage business financials and bookkeeping. And then the last webinar of the series will be on May 11th, and we'll talk about conflict resolution in the workplace. And Dawn La Rochelle from the Center for Women Enterprise will be the speaker for that webinar. So without further delay, I'd like to welcome Allison Ebner and Pam Thornton from the Employers Association of the Northeast. Welcome.
Thank you so much, Somalit. We're so happy to be here today, and I definitely called in the cavalry with Pam because she is our internal expert here at the Employers Association as our Director of Strategic HR Services. We're really happy to be here today talking about this. As small business owners, we salute you, we congratulate you. Very difficult climate on a regular average day or year, and that has been anything but, right, for the past year. So our hats are off to you, and we know how important it is that we share some vital resources with you. So I'm going to go ahead and share my screen, and we'll get going with our program here. Let's see. So just give me just 1 second. And just give me a thumbs up, Pam, if you're seeing that first slide. All right, great. Thank you, guys. So
a little, maybe it's kind of cut. I don't know if anybody else, is it cut off on anybody else's screen?
Is it anybody seeing that it's cut off a little bit?
Might just be my screen, which is okay.
All right. Are you able to see it though, Pam?
Yeah, I can see it.
Okay. So that's important that you can see it because you're sharing a lot of information.
Sure.
All right. So again, Pam and I are from the Employers Association. This is what we do. Employers Association, for those of you who, folks who probably don't know about us, we are a membership-based organization that supports over 1,000 member companies across New England with their people process. So anything compliance related at the state and federal level that you need to know to operate your business, we drive that information out to employers across New England. We also do things like employee handbooks. We do all kinds of HR audits, those types of services, and we do a lot of training as well so that employers can be competitive and stay strategic as they operate and grow their businesses. We're going to be chatting with you a little bit today about getting your ducks in a row, right? Pam is going to really run with the program. I'm just going to introduce her and I'll sprinkle some things in, but she's way, way more knowledgeable than I am on this subject matter. So we're going to talk about the differences between independent contractors and employees, the select issues that you need to know about at the state level and the federal level with regard to employment laws, some things that might tend to, kind of grab small businesses by surprise. You're all managing a lot. You're wearing all of the hats, right? HR, finance, operations. So there are definitely some legal things that we want you to know about. Avoiding legal pitfalls in the interview process. There's some do's and don'ts there as well. And certainly as it comes down to employee handbooks, do's and don'ts on what you can share in those handbooks as well. So I will turn it over to Pam. Take it away.
All right. Well, thank you. Thanks so much for everyone for being here, and thanks for the introduction and the opportunity to talk with you all. There's a lot of information here. I know that you're invited to put questions out in the Q&A. We certainly can keep an eye on that and make sure that if there's something that you don't understand, please stop me. And like Allison said, she'll be adding some information as well. So
Pam,
yeah.
real quick, there's a question. I usually don't interrupt you until the end of the presentation, but this particular question is asking, are the points you're speaking about today specifically to Massachusetts?
So we are going to talk about Massachusetts law, and we're also going to talk about federal law as well, because there's interplay and overlapping laws for both state and federal.
So those federal laws that you'll talk about will apply to other states, but there will be the state laws will apply only to Massachusetts.
Absolutely, and they're kind of detailed out, so I'll reference them. We'll talk about which ones are which, but the federal laws are, again, across the U.S., so it's federally speaking.
Thank you.
Okay, so this is, to kick this off, we start with the employee versus independent contractor concept. This is one of the big ones when we talk with small to mid-sized businesses, and sometimes with large businesses as well. But the difference between the two gets blurred sometimes, and there's a lot of implications around being an employee versus an independent contractor, and conversely. And I'd like to, if you would, just throw out into the chat, if you feel comfortable, if you have independent contractors in your cavalry. It would be good just to kind of see if anybody is using independent contractors. Even if you have one, it'd be good to hear that. Great. Okay, thanks, Nancy. Freelancers, Catherine, we're calling them independent contractors. So when I say independent contractor, I mean people that are on a 1099, so they don't get a W-2 as an employee of your organization. They get what we call a 1099, and they have to claim their own taxes. Okay, and Martha, you've explored it a little bit, and it's case by case. Okay, so want to go through this because there are implications, right? Oh, there you go. Thank you for that poll. that. Okay, so yeah, so far we've got pretty much half and half. So this is something that you are all probably familiar with, but some of you are actively doing. So that's great. So when we talk about an independent contractor, there's pretty strict rules on a federal basis, and even more strict rules in Massachusetts about whether or not you can be an independent contractor. And that's for a variety of reasons, which I'll speak about a little bit later on. But most importantly, what I'll say is if you're an independent contractor, you are going to have to claim your own taxes. And in some cases, that can be really great because independent contractors like to be independent. Some of them have their own businesses and they like to manage all of their own things. But sometimes it can be a little gray, whether or not we're an independent contractor or not, versus an employee. And again, these implications can be pretty significant. So again, looks like we've got almost half and half of you using that. So that's great. I'll just share the results. Everybody can see that. Nice. Thanks for doing that, everyone. So what do I mean when I say independent contractor? And why is it so tenuous, right? So an independent contractor is someone who pretty much goes about their business, whatever their business may be, of their own will. They are not bound by your schedule as the employer. They're typically not using your equipment as the employer. They're not following instructions or specific direction. They're really, from the creative standpoint, they're doing whatever it is that they do on their own and of their own free will, and are not bound by things like, what you're going to pay them. They most of the time command what they're going to be paid for something. You don't necessarily have a contract with these people that outlines anything other than what the fee agreement is. And the reason being is because as an independent contractor, again, they're paying their own taxes and they're not bound by a lot of the things that our employees are. As employers, when we have employees, we have all kinds of regulations, laws, payroll taxes. We have to contribute to retirement, all these kinds of different things that we have to do for employees versus the independent contractor. So I'm going to talk about that in a little more detail in a couple of slides here, but wanted to just kind of give you the framework and really have an understanding of how many of you are doing that, because quite frankly, if you're not following some of these pretty strict rules, you probably should be making them employee. We always say, if it walks like a duck and it acts like a duck, it talks like a duck, quacks like a duck, it's probably a duck. So, and the federal government, IRS included, Department of Labor included, who manages a lot of these employment laws and specifics, want to make sure that our workforce is getting what's due to them, as well as that they are getting the taxes that are due, the government's getting the taxes that are due to them. So there's some pretty strict purview and monitoring of whether or not you're an independent contractor versus an employee. And there's implications financially, and then also as we look at risk, litigation, things like that. So other thing we're going to talk about in terms of the working relationship is this concept of an employee agreement. So some of us have contracts with our employees. It's good news, bad news. We have this thing called at-will status in Massachusetts, and it's actually, in many states where it says you are an employee at will, which means I can leave your employment at any time I want to, and you can terminate me anytime that you want to. There's got to be more to it, right? A lot of times there's implications around why we let people go and making sure that we're doing it in a legal way. But generally speaking, at-will status says that we've got that freedom between us. Once we introduce what's called an employment agreement, it's really a contract that is going to outline what we want our employees to do, and it basically gets rid of at-will status. So it's one of these things where we may want to do it, but we have to recognize that if we do that, it's going to create some limitations for us as employers as well. No longer do I have this at-will status where I can just say, it's not working out, Pam. We're gonna part ways. Sometimes our employment agreements are ones that lay out what someone's going to be paid, and they lay out the frequency. They lay out, how long. And if we decide, halfway through the agreement that I don't want Pam to work there anymore, I might have to honor that agreement because it really is a contract that's been signed, and it's something that will hold up in court. So for those of you that are doing employment agreements, I will say that they certainly can be important. And sometimes the employee wants a contract. Please don't download one off the internet. Please make sure if you're going to, and you want to go down the road of having an employment agreement with an employee, that you use an attorney to craft it, review it, and walk the employee through the process. They will be able to make sure that you are protected as well as the employee is protected in the event that the agreement has to be canceled. Okay. I'll say go to the next slide. Good.
Sorry, Pam, hang on.
No problem. Any questions on that while we're advancing?
There we go.
Okay. So there is, as I mentioned, all of this, the issues around whether or not an employee is an employee or an independent contractor. If we go down the road and we say, well, it makes more sense. I'm not going to have the person on for very long. I'm just going to pay them $10.99, make them an independent contractor. I see this a lot in in smaller organizations, startup organizations, not-for-profit organizations. Here's the classic example of, we've got an administrative assistant, but we've hit a spike and we need more help. And so I'm going to bring in somebody to help that administrative assistant, maybe with the copying or the filing or the phone calls, and I'll just pay them $10.99. Well, another prong of this piece of whether or not you're an independent contractor or not is if you are doing something that is in the normal course of an employer's business. So if you hire another administrative assistant to help out, you can't make them a 1099 because you already have one who's classified as an employee. So that would be what we would call a misclassification. And here, again, in more detail is why this matters, right? So statistic for you in 2005, the Bureau of Labor Statistics reported that there were over 10 million independent contractors, which represented 7.4% of the workforce. If they truly are independent contractors and they meet all the qualifications of that, that's fine. But if they're misclassified, if you look at this piece where the Government Accountability Office said it costs the federal treasury $4.7 billion annually in income tax revenues. This is why there's this increased enforcement across all these industries. Again, happens in small businesses, happens in businesses where we potentially got seasonality and we need to bring extra people in. You've got to think through that process that they truly are someone that's just adding on, you're adding to staff, then you're adding to staff. You need to put them on payroll. You need to make sure that their income tax pieces are being adhered to. You're contributing, to Social Security, all those kinds of things for these employees. So again, and I know in past years, I know that a lot of the audits that the IRS has been doing is really around this misclassification piece. So they'll come in and they'll look at, your employee files, your payroll records. They'll look at, your general ledger and how are you paying people? What kind of vendors do you have? And if you have, a lot of 1099 people, they'll go through and want to understand what it is, what the role is. And it always winds up being that the burden of proof is on the employer. The employer has to be the one who is able to prove that they truly are independent contractors. And you can imagine how difficult that might be if you have an example like I referenced earlier, where you just have somebody who's doing something that actually someone on your staff is getting paid to do. So something that I see a lot, I know is being audited on a regular basis. So something to be mindful of and look out for.
And Pam, when those audits happen, sometimes that opens the door for other audits as well, right? So if they happen to get in the door for this misclassification, you could be exposed to other areas of your business, right?
Really good point. Really good point. So never do we ever want an audit, right? Usually audits don't mean great things. They always find something, right? Because they're digging for dollars most of the time. That's what that's all about. But truly, if they come in and they're looking at, your payroll records and your general ledger and those kinds of things, then they have the opportunity to say, well, let me look at these other kinds of files. Let me look at your benefits. Let me look at the, you don't want them poking around and having that opportunity to look at all those other things. So that's a great point. Okay, so when we talked about why it's important, certainly there's other things that I referenced, but federal and state labor laws as it pertains to the employee don't apply to independent contractors, right? So you can imagine, why, people like the MCAD, the Massachusetts Commission Against Discrimination, is also very interested in how many independent contractors you have on board, because none of the labor laws are really going to apply to an independent contractor. They're going to apply to employees. The employer is bound and responsible for making sure that they adhere to labor laws for their employees, but not for their independent contractors, right? So this is, again, another reason why misclassification is something that you want to make sure doesn't happen, right? It creates a lot of employer liability if they're misclassified. Another great point, former independent contractors can claim entitlements given to employees. So if for some reason, you have misclassified people, they can go back and they can look at these folks that were misclassified, and they may have entitlements. They may be entitled to past benefits that you had provided, such as health insurance, maybe even a pension plan, or any other kind of employer-provided benefits that you may have provided in the past. They could be entitled to that. And then also the IRS can go after the employer for failure to withhold income for any of the payroll deductions. So again, the SUI, the FICA, the unemployment, I mean, all those things apply to regular employees, but they don't apply to the independent contractors. The IRS takes a look at it, they get a hold of it, and they find that you've been misclassifying folks. They can be coming after you for back taxes, which can be expensive, troublesome, something we don't want to deal with, right? So making sure that you classify people the correct way, you're really looking at, are these people completely free to make their own decisions? Are they using their own equipment? Are they, making decisions that you don't influence around schedule and pay? Those kinds of things are really things you need to take a look at when you're deciding whether or not independent contractor or employee. Okay, so financial and legal exposure, the list goes on. We talked about the tax penalties that can come along with that. Certainly there can be increased penalties if it's discovered that this is willful. So let's just say, you do it and, you think you're okay, but if there's any indication that you really did it willfully, there certainly can be increased penalties for that. The other thing that we look at is the Fair Labor Standards Act, making sure that when we're paying independent contractors, sometimes we come up with an idea or an amount of what we think they should be paid. If it's decided that these folks really should have been hourly employees and they kept track of their time, what if we weren't paying them minimum wage based on that whatever amount of money that we were paying them as a 1099? We might not be meeting the requirement for minimum wage. We may not be meeting the overtime requirement, which is paying employees time and a half for hours worked over 40 hours, or if they were working more than that, we may owe them overtime. And in the state of Massachusetts, there's something called treble damages. If we are found to not be paying people appropriately and we owe them anything, we owe it times 3, which is what treble damages mean. So whatever we owe these people, we're going to pay them, and then the employer is going to be dinged for fines, which could be, again, times 3, which is it's very costly. There's also something called the National Labor Relations Act, which applies to employees. Any employee, two or more employees that are talking about, something about their manager, something about their working conditions, anything around that's protected under the National Labor Relations Act for employees. If you have people that are independent contractors, that's not protected. Why does that matter? In case they want to unionize. So if you had made it so that these people were independent contractors and not employees, you've taken away their right to potentially unionize by having what they call protected concerted activity, being able to talk amongst themselves about their working conditions, about their managers and whatnot. You've taken that away because independent contractors cannot do that. That's another implication for the employer. Then we have ERISA, which is the Employment Retirement Income Security Act. So that's available to employees. It's one of the highest benefits out there. Been around a really, really long time, where we offer health insurance and other benefits to our employees. We can't offer that to independent contractors. So again, if we're not classifying them right, we're taking that right away from them to have access to our health insurance plan and potentially any other benefits that we offer. I talked about the laws. So employees are protected. Anti-discrimination, anti-harassment laws. We have laws that we're going to talk about here that protect our employees, again, would not apply to independent contractors. So we could be held liable for taking away these rights by misclassifying our employees. And then certainly as employers, when our employees, do things that are illegal, right, we are responsible for them. And, we as employers would be the ones to either support them in a court of law, depending on the law or that they've broken. And again, that liability piece, that protection, we've taken that away if they are misclassified. So lots of legal exposure, certainly a lot of financial exposure. So we want to make sure that we get that misclassification piece right. We're classifying people the way that they should be, because there's a lot of implications. So the reality is, some of us are small businesses. Some of us don't need to hire an employee, a full-time employee, or even a part-time employee. Maybe we only need them a couple of hours a week, to help us out. We can hire temporary or contingent workers, right? So we could do this on our own. We can hire them. We don't have to hire full-time people only. We can hire them temporary. We can hire them, on a seasonal basis, or we can certainly go out and work with an agency. There's agencies that employ people that they can place at your worksite to help you manage your surges in business or your turnover, those kinds of things. There's also what we call PEOs, they're professional employer organizations. So they will basically, and you've probably heard this term, so I'm just going to use it, they'll payroll somebody for you, right? So you can hire someone through another agency who's already taking care of all this other stuff that we just talked about, all the taxes, all the workers' comp, anything around, the laws and the liability and the health insurance, and, all of that is taken care of by the employer that they work for. What happens though, when you do that, you pay a fee to either an agency or a professional employer organization, and you engage what we call joint employment. Okay, so you're not completely off the hook. It's not like you can just do whatever you want with someone else's employee. You're still culpable in terms of making sure that you are treating them fairly, not discriminating against them, paying them fairly, paying them for the hours they work, paying them overtime, the list goes on, right? But you really are what we call a joint employer. So if anything does come up, if there's any kind of liability or litigation or mistreatment, if it happens at your work site as a result of this employee from the other organization being at your work site, you could be culpable and responsible for what happens with this employee at that work site. So it's called joint employment. There are all kinds of, we could spend an hour talking about all the tenets of that. There's been states, I think there's 10 or 15 states right now that are trying to say, well, this whole thing is ridiculous. If I'm hiring you through an agency, why is it joint employment? What's the point? They're trying to get it thrown out. But the bottom line is you're working together to employ this person. So you're all responsible for the person's work, how they get paid and all those kinds of things. So it is something that you do have to consider, but it's certainly a safer option than this classification. And it just means that you've got to be treating your employees and even your temp and contingent employees from agencies really the same. So using the same kind of policies and practices to administer across the organization. You just treat them all the same way. Questions on that? Okay. All right, federal law. So we talked that there would be some interplay and some other laws to consider. Certainly from a federal standpoint, there's a lot of laws, but I think the ones that are critical and important to you in this session is really thinking about Title VII of the Civil Rights Act of 1964. Basically says that if you're an organization of 15 or more employees, you cannot discriminate against somebody because you're making decisions about their race, color, national origin, gender, sex, pregnancy, or religion. So you're not going to want to make decisions based on those protected categories, is what we call them, in employment, hiring, promotion, termination. If you make decisions as a result of those protected categories, you could be in violation of this law. So what I always say is, focus on the work, focus on what it is that you want your people to do, and those are the things that you make the decisions about when you're making decisions about what you're going to do for promotions or hiring or even training. Plays a role there. We have something called the Age Discrimination and Employment Act of 1967. Again, applies to 20 or more employees. What I'm going to say is, you know, this is the law where the over 40 category is protected. It's you know, you hear it out there all the time, age discrimination. Again, same thing. If you're making decisions about me because of my age, perfect example is, and we see this a lot, there's a lot of case law out there around, you know, technology. You know, if I'm a, you know, 60-plus-year-old worker and I can't learn the new computer system and I get terminated, hopefully it's not because I'm, you know, over 60 or 60 and over and, you know, didn't get an opportunity to learn the technology. Certainly, we aren't going to make decisions about people based on age, but it does happen. So when we are making decisions around, again, you know, things like hiring, termination, promotion, that we're really focusing on the work and what it is that they're doing and not making decisions based on their age. And then we have the Americans with Disabilities Act, which came out in 1990. Again, and there's an even more strict act called the American with Disabled Act Amended, which came out 6 years later because people weren't listening and they were still discriminating against people because of disabilities. It's an even broader law, but basically says people need to listen, okay? If we have someone who, you know, is disabled, or whether they disclose it or not, if they appear to be disabled, we don't make decisions just based on a disability, because certainly disabilities, the broadest category that is out there, potentially could be reasonably accommodated. Okay, we don't necessarily have to put the elevator in the building for the person who has the wheelchair, but the example would be, is there some other way that we could potentially reasonably accommodate someone to do that job because they've got great skills and experience, and, you know, make them part of the pool of candidates. So could we move the job to the first floor? Could we make it, you know, so that the person can do that job because they're a good candidate? So we don't automatically just not include somebody in our processes, hiring, termination, promotion, and whatnot, just because of disability. Okay, so those are some of the basic federal laws that are important to know. I know I'm kind of going through them quickly, but if you have questions, certainly jump in. And somebody keeps track of my time.
Don't see any questions on the chat yet. Yeah, thank you.
You're welcome. So Massachusetts.
I mean, that could also mean that we haven't said to people, you know, this is time to ask questions. So if you do have a question, let's give Pam a little breather here and either raise your hand or type your question in the chat.
Great, thanks, Emily. And certainly, I think that was good advice. You know, this is information we can email out to you, but the details of it, writing it down, I think is important as well. We can always reference back to it if you have questions about it. In Massachusetts, if you work 6 or more hours, you need to give a 30-minute unpaid meal break. That's the minimum of the law. You know, there are employers that do more. If you're doing more, you need to make sure that it is paid. So I know pretty traditional in a lot of organizations, especially in the manufacturing industry, just because it's tough work. You know, we do a break in the morning, break in the afternoon. If you're going to do those kinds of breaks, you need to pay for them. The only thing that you're really bound to do is 6 or more hours, an unpaid 30-minute meal break. Doesn't mean you can't do more, but that is the minimum that we have to adhere to. Massachusetts sick time, there's a sick time law that came into effect back in July of 2019. And at a minimum, if you have 11 or less employees, so, you know, depending on the size of your organization, you will accrue sick time. So everybody accrues 1 hour of sick time for every 30 hours that they work. Again, so that is the minimum. And that is up to 40 hours a year. You have to earn it. So you have to work to actually earn the hour. You can't use it until you've been with the organization for 90 days. So you continue to accrue it. And again, that is the minimum. So there's a lot of employers that do more than that. There's some that were doing less though, and some that were doing none. And so what happened was people were coming to work sick. And, you know, sometimes people wouldn't come to work because they were sick and they were losing their jobs. So that was the intent of this law, to make sure that people, you know, get the time. If you have 11 or less employees, you don't have to pay for that hour for every 30 hours that that person has of sick time, but you have to allow them to take the time. Okay. And above 11 employees, you have to pay them for that hour. Again, up to 40 hours a year. Okay. Massachusetts paid family medical leave. I'm sure if you don't know about it, you certainly do this year. We started collecting the taxes last year on this. I'm not going to go through all the calculations because, quite frankly, I can't remember them off the top of my head. But this is protected time for our employees coming out of a fund that we have either funded for them or they have contributed to at some level, where they can take time to take care of their own serious illness or their illness of a family member. The family member piece doesn't actually go into effect until July 1st, but as of right now, people can take time for their own serious illness or for the birth and bonding of a child. And again, that's, you know, mother, father can take that time. They do have to apply through the Mass Tax Connect site, so through the state. It's not something that you as an employer have to get really involved in, but then I'm going to say it's something that you need to get involved in. And here's why: because you need to know if they are applying for it. You need to know if they're not applying for it. Even if they're not applying for it, it's still protected time. So it's a time in which they can take this time. They can either get paid through the state for it out of that fund, or you know, they can take it out of their own bank of time if you have a bank of time for them. But it's protected time. It's time that you can't say, you know, you can't be retaliatory in any type of way. You can't give them a bad review because they're taking time. You can't, you know, make a job change because they're taking time off. You know, it's what we call protected time. That is, you know, as far as the employer is concerned, you really have to just let it be. They're allowed to take it. There is a calculation. I think they have to earn, Allison, maybe you might know the number. I think within the year they have a certain number of wages they have to earn. I don't know what it is, but that would take them over to be eligible for it. So they have to apply for it. They have to be approved for it. And the Department of Family Medical Leave is working in close contact with employers. So you have to designate someone at your company to be the contact with the Department of Family Medical Leave, because there is back and forth communication that happens through that Mass Tax Connect site to, you know, make sure that, you know, time that's being requested, you're communicated to about, because again, it's protected time. So anything you want to add on that, Allison?
No, I think the one, well, I say no, and then I'm still talking. Yes, I think the one thing that I would mention here that's very helpful is the Paid Family and Medical Leave website for the state is very, very helpful, informative. If you go on there, even if you Google it, or we can get the link over to you all, it's got a portal for employers specifically that talks about the CAM reference, those calculations, but really important information. You can also sign up as an employer for updates from the department. So when they make changes to the system, you'll get notified. For example, very, very brand new this week, the employer portal of their website has been closed because too many employees were going to the employer portal to file claims. So they shut down the employer portal. It is reopening next month. I believe the date is May 11th, but employers are going to have to verify that they are an employer to be able to get that portal opened for them. And you want that access because you want to be able to go in and look at the claims that your employees have filed, where the process is. They're going to be reaching out to you as an employer for additional supporting documentation. So you're going to have to go on to your Department of Revenue portal essentially and be able to provide a quarterly amount that you've paid into the Department of Revenue to be able to verify that you are in fact an employer. So we've got a document that really just came out from the Paid Family Medical Leave Office that we can share with all of you post webinar as well. We'll make sure that Somali gets all of that information for you.
That's great.
And Pam, I do have a question here in the Q&A. Did you say that the paid family leave, that someone could take the paid family leave without applying to the state and they just wouldn't get paid for it?
So if I think I understand this question right, you don't have to apply for it, right? But you're not going to get paid from the state if you don't apply for it. You could say, I just want to take my PTO time. I've got my own vacation time through my employer. I don't want to apply through paid family medical leave. I don't want to go through that process, and I'll just take my PTO time. That's completely fine. But as an employer, you need to record and make sure you've got it in your paid family medical leave file that Pam took 2 weeks off and she used her PTO time. Because what happens is, if 6 months from now, I decide I want to take some paid family medical leave time, the Department of Paid Family Medical Leave is going to count those 2 weeks. Even though you got paid for it, it's going to come off of the 12 weeks that you're entitled to through the paid family medical leave. So you can't say, I want, those additional 2 weeks. I want a full 12 weeks. You're only entitled to 10 because you've already taken it, which I know is a bit confusing. But again, that website will be very, very helpful. This is why a lot of employers, small plug, work with us because we have a hotline and you can talk to an HR professional about some of these things when it happens, but it does count. They will not get paid for it if they don't apply.
Okay, thank you.
You're welcome. Massachusetts Pregnant Workers Fairness Act, very similar to the federal legislation, really just means you cannot discriminate against someone because they're pregnant. So classic example here is we're trying to do the right thing. Pam's pregnant, she works in the warehouse, and you know what? She's ready to deliver. She's, a full 9 months plus pregnant, right? And we just want to, make sure she doesn't get hurt and help her, get through this. So we don't want her lifting boxes. So we move her to the other end of the warehouse and we have her, putting together some, pieces instead. And that could potentially be considered discriminatory. I didn't ask for that. My doctor didn't tell me that I had to do that. I didn't bring in a note that said that had to happen. So even things that come from a place of good intent could be considered unfair. So my best advice around this piece is just making sure that you are not making any changes to anybody's job, who is pregnant as a result of any other decision than from a doctor's note. So you're really following whatever doctor recommendation you have for these pregnant workers. And that's pretty much been around for a long time. Again, it's kind of another reenactment of the Pregnant Workers Fairness Act. And it, again, has happened because people aren't listening. So they take the act and they make it stronger and with higher penalties for people, for all of us. So something to be mindful of. Massachusetts Pay Equity came out a few years ago. This is the concept of making sure that female and male workers are paid equal pay for equal work. What we'll say is, the law came out, people did their due diligence and went through and made sure that, they did an analysis of their workforce and their pay practices and, brought people to where they needed to be from a pay standpoint. But there hasn't been a whole lot of case law, and hopefully that's because people aren't feeling like there's inequity. I think there's more to come on this, quite frankly, but it is something to be mindful of. You should be looking at your pay practices, doing an analysis of female versus male, male versus female workers, and making sure that it is equal pay for equal work. So looking at things like the complexity of the work, degrees necessary to do the work, really analyzing that this pay is equal pay across the board. Massachusetts Personal Record Law basically says that an employee can request a copy of their personnel file within 5 days. So not business days, 5 days. That includes weekends, even if you're not open on the weekends. You have 5 days to provide a copy of it. What I will say is you can charge them for making copies of it. Hopefully the personnel record isn't that thick that you need to be worried about doing that. Best practice is to really have your employee, if they are still working with you, come in and view the record. So if they ask for a copy, you can say, you can come in, you can view the record. It's better to do that. A lot of times when they're asking for a copy of it, it gets concerning, like, why are they asking for a copy of it? Who are they going to give that copy to? Are they, did they hire counsel? What does that look like? So giving the employee the opportunity to view the file is also considered to be meeting the tenets of the law. And then we have what's called the Small Necessities Act. Only in Massachusetts, it's 24 hours of unpaid time that your employee is entitled to in a course of a year that they can use to go to a school play for a child, attend a soccer game. We call it the Small Necessities Act. I hardly get any questions about it, on the hotline, because bottom line is it's unpaid time. And a lot of people will just, they'll take it out of their PTO time, or they'll adjust their schedule with their employee. So we don't hear a lot about that, but I like to make sure that people know that it is out there. There's a couple of things in the chat here. I just want to take a quick look. Oops, and I lost my screen. Sorry. Are those questions for me?
No, not so far. Thank you.
Oh, you're welcome. Harassment in the workplace. So we're talking about sexual harassment here. There is been around, again, a long time, sexual harassment laws. 2 types of sexual harassment. What I'll lead off by saying is that the harassment has to be based on sex. It has to be something of a sexual nature. There are 2 types. One is called quid pro quo. It's a Latin meaning this for that. So you do something for me, I do something for you. That's basically what that means. And it has to be, again, a demand for sex, some kind of sexual favors in exchange for a job benefit. So, I don't know, a promotion, better working conditions, higher pay, those kinds of things that are truly job benefits, again, based on sex. Same thing with a hostile work environment. This has to be, again, of a sexual nature, something, that is pervasive. It happens, it's creating an intimidating or an offensive work environment that's based on sex. It could be treating a woman as little as, right, treating a woman, in a hostile way that's again, based on sex, something pervasive, using, verbal or nonverbal conduct in a way that interferes with that person's performance. And there is no, list that I can put up here that would say, this is going to be sexual harassment and this is not going to be sexual harassment. This is all rooted in basic respect, right? So, and pervasiveness, and it's all driven by case law, driven by, the damages that people receive for these kinds of claims that they bring up. It would go to the MCAD, which is the Massachusetts Commission Against Discrimination, if it's not something that we can handle within our own workplaces. So the takeaway here is to make sure that your employees understand what sexual harassment is, because you have a policy in your handbook that explains what it is, what the implications are, what the process is to report a claim in your workplace, who they go to, and that you provide some kind of training for your managers, the people that are modeling behavior, leading your workplace, making sure that they again are modeling good behavior and that they're not harassers. I'll say that harassment can happen supervisor to subordinate, subordinate to supervisor, but it can also happen amongst coworkers. It doesn't have to be male to female, female to male. It can be male to male, female to female. It can be outside your organization, and it comes back into your organization. You know, it happened at the Christmas party, and now we're talking about it, you know, in the lunchroom. So it's a pretty involved law, and again, rooted in respect. If we're treating people with respect, and we're not, you know, using sex in a pervasive way, you know, we are hopefully adhering to this law and training our people about what it looks like. A lot of this comes up and it's not ill intent. It's not coming from that place, but it winds up going to that place because it's behavior that we don't address. So, next slide. So some examples. Again, I don't have that list, but sometimes offensive, you know, banter, the back and forth, you know, off-color sexual jokes, inappropriate entertainment, you know, looking at videos online in your office. I'm going to say, you know, things like, you know, everybody has a cell phone. Are we allowing them at work? And how are we allowing them? What are they allowed to do on them? You know, making sure that we're monitoring those kinds of things and being aware. Harassment can also be excluding someone. So, you know, on the basis of, you know, again, sex, and making gender-based assumptions, certainly, you know, about people's sexual orientation, you know, how they behave. So anything at all that's creating intimidating, offensive environments is what we're going to call, you know, hostile work environment harassment, and you know, anything of that disrespectful nature that is pervasive and again is based on sex is going to be sexual harassment. I also wanted to address discrimination in general. So this term unlawful discrimination, we hear this a lot. You know, you discriminated against me. Well, what does that mean? And it is very specifically, you've treated me differently because I'm part of a protected class. Okay? And if you haven't heard the word or the term protected class, there are many categories that are protected on a federal basis, you know, state by state basis. The list is pretty long. And Allison, if you can go to the next slide, what I'll say about this list, these are categories in Massachusetts that are protected, and it's pretty long. You know, and I will, you know, read them because I think it's important for us to hear them out loud. But things like race, color, religious creed, national origin, your ancestry, your sex, your gender, your genetic information, anything about your genetics, your handicap or your potential disability, your pregnancy or a related condition to pregnancy is protected. Participating in discrimination complaint related activities, we call that retaliation. So if I'm part of an investigation or I was a witness and an employee is suing the company and I'm brought into that, that's protected. My age is protected. My sexual orientation is considered a protected class. Any kind of veteran or military status. And gender identity or expression is also protected in Massachusetts. When you look at that list and you really read through it, you can see, you know, we're all in probably more than one. We're all in age, we're all in sex, we all have a, you know, a race. I mean, really, again, this goes back to that concept of being rooted in respect, right? So if I'm making decisions about your employment, your candidacy, your promotion, because of any of these things, it potentially could be discriminatory, right? It's really about thinking about, you know, we're all protected in some way, and what are the reasons why I'm making a decision about somebody? If it's come to find out, you know, through the investigative process that you really made a decision based on my race, based on my sex, you know, because I'm a woman or whatever, then yes, you know, you're going to be held, you know, to the threshold of, you know, you discriminated against somebody in a protected class. But if we're treating people with respect, we're probably not focusing on these kinds of things. We're really focused. We should be focusing on what it is that they're doing in their jobs and how they're doing their jobs. But that's the whole concept of discrimination and protected class. So again, it's treating me differently because of one of these things. That's the only time that it's considered discrimination and unlawful. Okay.
And Pam, someone put in the Q&A also, just to, make the point that sexual harassment can happen to both men and women. And I know this is a point that you made. You talked about that a slide ago, but and I think it's important for us to remember that too. And so I thought that was an interesting point that was brought up.
Absolutely. Yeah, it really can happen to anybody. Yep, it's not always the male, right? I've seen,
Things should be taken seriously until, you
absolutely.
investigate.
Right, right. I've heard, women, two women, or two men, it really doesn't matter. It doesn't have a lens for that. But you're absolutely right, Sumley. I think, when you think about um, any kind of harassment, discrimination, any kind of complaint, um, in general, even bad behavior, right? Because bad behavior, until we really look at that behavior, we don't know what's driving it. They should all be taken seriously. Complaints, even the ones that are the chronic complainers I cannot believe this person's complaining again. We have to take those things seriously because quite frankly, if we don't address it and we don't figure out how to make it stop in between our four walls, they go to places like the NCAD. They go to the Massachusetts Against Discrimination. They file a claim. Every single claim that gets filed has to be reviewed. And what that means to the employer is that you've got to get legal counsel to respond to that claim. It's mandatory. And it costs you money, it costs you time, it costs you resources. So being able to really support and address issues with your employees when they bring them to you, and to your point, Sumley, investigate to the degree that we can, the best that we can, and really understand what's happened and making it stop is really our only responsibility here, is to make sure that whatever it is stops, whether it's harassment, discrimination, or quite frankly, just bad behavior. You need to make it stop. Great point. Okay, legal speak, interviews. So probably one of the hardest things we have to do, right, is hiring someone and terminating people, right? But hiring people can be, especially these days, so challenging, right? With placing ads and in the olden days, years ago, we place an ad, we get all kinds of candidates, all kinds of responses, and now we just get a few. So we want to make sure that we're taking the opportunity to make these interviews engaging. There's a little bit of sales, like a little bit of a sales hat that has to go on when you're selling your company, right? Making sure that you're being transparent about who you are, because we don't have a lot of candidates out there. We don't have the opportunity. We don't always get the opportunity to talk to somebody more than once. So with all that being said, we also want to make sure that the interviews that we're conducting are legally defensible, right? So we're not asking questions that aren't legal. We aren't asking questions that are leading, that could potentially be leading people to answer things that might be illegal, like, do you have daycare? Well, I don't, I may have talked about how many kids I have, but I don't want to be asking about daycare, right? Because that really doesn't matter about the job. It all goes back to what are the skills and experience that it takes to get somebody to do the job? What is it that we want them to have in their toolbox to make sure that they're the right candidate who can do the job? So we talked about all those protected classes. We don't want to ask questions, anything around those protected categories, right? So, if we're digging in, we really want to dig into what are the examples of the things that they've done in their jobs to really help us understand what their skill level is and what their experience is. You've got to be sensitive, but you've got to be mindful. What I'm going to say is, please have a list of questions that you have vetted out for yourself when you're doing an interview. And if you need to bounce them off somebody else in your organization, make sure that they aren't inadvertently asking questions about someone's protected class, right? Again, really focusing on the skills and experience of the job that you are recruiting for and that you're interviewing for. In the state of Massachusetts, you cannot ask about previous salary. This goes to that mass pay equity law. So the intent here is, if I ask you what your previous salary was, if I'm a female, we'll just throw an example out there, and I give you what I was making in my past job. Now you've got an indicator of how I might be able to get you into this job. I could offer you more money, but was it at market rate to begin with? Was it equal with what perhaps my male counterparts were making for that same job? You don't want to be asking about salary. You want to be asking about skills and experience. And it's best practice is, before you go out to market and start to recruit for a job, decide what you're going to pay. Decide what you are going to look at for a range for that salary, for that position. And do it based on data. There's lots of market surveys out there. We offer them. And there's definitely ones out there that are free as well. So do some research about what market salaries are before you even start to go down that road. But don't ask about salary. It's not legal. Better off tell people what the range is. You say that range is 15 to 18 an hour. Well, I want 18 an hour. Well, it's commensurate with experience. That's the range. So at least you're being transparent about what you're offering, right? Again, just be careful about descriptive information. It can be harmful. Again, it might be something that's referencing a protected category. It's hard when we're in these interviews, right? We're trying to sell our organizations as the best place to work, or if we want you to come work with us. And then also trying to balance, having these conversations and building rapport with people, and really trying to get to know, are they a good fit for our organization? It is very difficult to have these interviews, especially if you don't have a list of questions. You can see why this could be really helpful if you have a predetermined list of questions that you can use over and over. And honestly, the questions, if you use the same ones for the same types of candidates, for the same types of jobs, if you're ever questioned, you have that list that I asked everybody kind of the same questions. Certainly we go off script a little bit based on people's backgrounds and the resumes, but you're going to want to make sure to have that list of questions.
Hey, Pam, I think we have a question. Speaking of questions.
Okay.
Speaking of questions, yes, we do have a question in the Q&A that's applicable to what you're talking about right now. It's a little different. So the question is, if a woman comes into an interview and she's obviously close to delivery or she's pregnant, what are some of are there any safe questions that you could ask her in regards to her condition?
A great question. I'm going to go back to what I said before. What's the job? What do we need to do the job? All the questions, because we have a preset set of questions, right, for this job that we already put together and we've thought out, should be about the skills and experience. Really doesn't matter if the person's pregnant, because you know why? We can see that they're pregnant. So we already know that. Unfortunately, we can't unsee if the person's obviously pregnant. So we know what's going to happen, right? We know that they're going to go out and take care of a child at some point, right? But you're going to want to make sure that you are digging into and you're really understanding, particularly for the pregnant person, right? Because you don't want it ever be to be misconstrued or perceived as you're being discriminatory. So you're going to want to make sure you completely have an understanding of whether that person is qualified or not to do the job that you're asking them to do. So I would say stick to your questions, and again, make sure you really understand that. Because just because the person's pregnant, what if they were the best candidate, right? You had 4 and that was the best one and they were pregnant. Now you've got a problem. Now you got to figure out how to make that work for you, right? Because you want the best candidate. You're going to have to talk that through. There's no reason after you make an offer to someone why you can't talk with them about how, what the work schedule will be like. You can ask things like, can you meet the requirements of this work schedule? You can talk about the projects that you're working on and, what the timelines look like. And they may offer it up to you, so you have an idea. But I wouldn't make decisions based on the fact that the person's going to be out on FMLA, paid family medical leave for a couple of weeks because of a pregnancy. And anybody who's ever hired somebody or had to go through the hiring process knows it's hard to find good people, right? Being out for a couple of weeks or a couple of months for a pregnancy or a broken leg or cancer treatments or whatever else, it's a blip. Finding good people and keeping good people is what's important. So focus on the skills and experience. The other thing we say is please keep your notes job related. Again, if you're ever called into question about why you didn't hire somebody, you're going to want to have notes, number one. Some people don't take notes, so make sure that you do, make sure that they're job related, because if they're ever subpoenaed and they have to be used as part of the court case, you don't want it to say Pam's pregnant and I don't, get pregnant, period. You don't want that on there, right? Not job related, because they are discoverable in the event that there is litigation. So always assume that your notes are public. They're not subject to the attorney-client privilege necessarily. So again, they could be pulled into litigation at any point in time.
Great, thank you, Pam.
You're welcome. So unintentional oral contracts. So we talked way in the beginning about these employer contracts, and they're usually signed, and they're, if they're signed, they're binding. If they're written really well, they're even more binding. You want to always do your best if you've decided that you're not going to have an employee contract, that you want to preserve your at-will status and you want to have at-will employees. Be careful of saying things in interviews that could be construed as an oral contract if it's ever called into question, like, why didn't you hire me? So saying things like, as long as you follow the rules, you'll have a job here. Well, down the line, 6 months later into the job, you decide to terminate them. Well, you said, just as long as I follow the rules, I'd have a job here. You've got to be really careful about if that ever comes up in litigation, you're going to have to defend it. The burden of proof is always on the employer. You'll always get a written warning before termination. Well, sometimes we don't always give a written warning before termination, right? And so that could be called into question. You want to stay away from words like always anyway, I say. Be sensitive to statements concerning future earnings and length of employment. So, talking about increases when they haven't happened yet, don't do that. Certainly, it's encouraging, right? You want to figure out ways to retain people. You can talk about what you might be working on, but you need to make sure that people know that it's not guaranteed, that it's really, a potential, but not guaranteed. Speaking generally about a position's past salary history, again, we kind of already talked about that. You want to be really careful when you're digging into those kinds of things, that you're not revealing anything that you don't really want to know. Okay. Employee handbooks. So, there's a couple of schools of thought out there. Some people say, having an employee handbook is good because it helps us. It gives us a guide on how, we administer policies and practices in our organizations. And then some people say, well, if I have a handbook, then I have to follow it. And so that's exactly true, right? It really is a guide for your employees. It's something for, all of your employees to understand who you are, understand how you do things, understand, what the goals are of the organization, what the benefits are for their employees. It really should be written in like 8th grade language. Please don't put, laws in your handbooks because your employees aren't going to know what they mean, and you don't want them in there because if they start investigating, then you're on the hook for having to explain all this stuff. So it really can be a useful tool for managing employees. I'm definitely in the camp of having a handbook. If you don't, I always say, well, if you don't have a handbook, you don't have policies, you don't have things for people to follow. So what are they following? And so I think it is an opportunity to make sure that everybody is on the same page. And it absolutely improves employee relations. It manages expectations for people if they know how attendance is going to be handled, how performance management is going to be handled, what's the policy on it. Well, I go to my handbook and I can look at it. The only thing I'll say about this is please don't put anything in your handbook that you're not going to use. And that really can be a detriment detriment. If you say you're going to do something, and you have a policy for it, and it's in your handbook, or it's, you know, on your intranet, or it's something you hand out every year, just make sure that you do adhere to it, because it can be troublesome if you don't. We don't want to be having policies that we're not actually using in our handbook. Okay? Which I just said. So here's the other piece, right? If you are, you know, an organization that has, you know, way more policies in your handbook that you're maybe use, you know, here and there, but not consistently, consider taking them out. You know, you should be looking at your handbook at a minimum on an annual basis, really looking. Not only do the laws change all the time, but our businesses change. Look at this past year and all of the different things we've had to deal with, remote work and, you know, hybrid learning and all kinds of things. I mean, it behooves us to take a look at this guide if we have one, at least annually. And then making sure that, you know, we're not picking and choosing. If we have a policy, that it applies to Pam, it applies to Allison, it applies to Sung Lee. Like, you can't just have policies that are just for, you know, certain people. You have to make sure that your managers, your leaders, the people that are working with your employees and administering these policies understand them, and that they're accountable and they're responsible for making sure that, you know, their employees, again, are following them and that they're administering them fairly and equitably. Because if you aren't, this is another legal thing that could happen, another risk, breach of contract claim. So these handbooks are policies. They're basically things that, you know, we say we're going to do. And if we don't do them, depending on what it is that we're talking about in the policy, it could be something an employee files a claim under breach of contract. So something to be thinking about. Always include disclaimer language. So what I mean by that is, you know, this is the most current handbook. You can always have a disclaimer that, you know, it's up to manager discretion, up to supervisor discretion, especially when we're talking about leave of absence, and, you know, things like that are non-statutory, like vacation time. You want to make sure that you've got disclaimer language in your handbook. And again, keeping the language really clear, very generally speaking, using words like I may do this instead of I will do this can be helpful as well. Some of the components in an employee handbook, there's a list here. I can go through it, but, you know, we want to talk about this at-will employment piece. You're going to want to do that as much as you can, you know, throughout the handbook. Really, just, I think this should be a takeaway for everybody. It's kind of a checklist, right? So addressing overtime, how you treat your confidentiality of your information, making sure you've got anti-harassment and discrimination policies in there. Again, all the laws that we talked about, you've got policy language in there that says we are aware of it. We want to make sure that you're aware of it. Looking at if you have expenses, how you reimburse that, what your policy is around social media and conflict of interest. Just some examples of things that go into handbooks. Go to the next slide, Allison. Again, more examples. You know, again, this is a guide for your employees, right? So we want to tell them what they can expect. So we want to make sure that they understand what the orientation process is. You know, what if they want to look at their personnel file, what the rule is on that. What they get for holidays, how to apply for health insurance, what they get. You know, is there rules around solicitation? Can I just hand out whatever I want? Discipline, workplace violence, are we drug testing? Again, and making sure that you're including those disclaimers. I'm kind of flowing through that because I'm not going to go through every single policy, but here's kind of an idea of what you want to have in your handbook. All right.
And we lost Somali somewhere along the way. I think she dropped off the call. So that's not good. That means Pam and I are in charge. So here she comes. She's back.
Good.
The nick of time before we were going to take over the whole program.
That's all right. Sorry about that. My computer decided to quit on me all of a
Mind
sudden.
of their own sometimes, right?
Yeah, that's why I have you guys as co-host.
There we go.
Thank you so much. That way there's a backup plan. There's always
Absolutely.
a backup plan. Great.
Sure.
So at this time, I guess you guys have already asked, if there's any questions from anyone. Your contact information is on the screen, so folks can feel free to contact you to follow up. You'll be sending me some additional either links or documents that you want me to send out to folks for everyone who registered via Eventbrite. That's what I'll do. I'll send you an email to via Eventbrite with those that information. And yes, so any questions for Pam and Allison while we still have her with us? Thank you so much for doing this today, guys. This is such an important topic. We get a lot of questions on these, and unfortunately, we're not the HR experts. We know a lot about HR, and the laws, but we certainly want to make sure that we give the folks the information that's definitely accurate.
Absolutely.
All right.
And if you have questions, I'm happy to. I know I went through some of those policies pretty quickly. I wanted to save some time for questions, but feel free to reach out. I'm happy to answer questions if you have them.
Great, thank you so much. And so I'm going to show one more time on the screen. This is part of a series of webinars that we're offering this in April and May. And the next one will be next week, Managing Your Business Financials and Bookkeeping with Katisha Galishaw. So if you haven't registered for that one, there's still time to register. These webinars are free. And the following week, the last webinar will be May 11th. And thanks again to all of the organizations that are co-hosting these webinars. We really appreciate you. And I can see my face slowing down here with my with my internet. So I'm gonna be quick on this. And thank you, ladies, so much for being here today. For everyone else, let's see. There's one last question here in the Q&A I'm trying to open. Can you guys read that on the Q&A?
Let me grab it. I'll grab it. Here we go.
Yeah, go ahead and grab it from the Q&A. My computer's been a little slow.
Oh, so Heather wants to know if you can send the link out to register for the other programs. How would they get that?
Oh, yes. So good question, Heather. So it is on Eventbrite. The sign up for the other webinars. Let me see if I can. If you go on Eventbrite and you just search for fundamentals of running a successful business, it will definitely come up. I am going to try and copy this link without kicking myself out of the Zoom meeting again. Hold on. Let's see if I can get it on here. To all.
While you're doing that, Somalia, I want to mention that Darlene, who's on our team, posted in the chat those links to the paid family leave website that you might need.
Awesome. Thank you,
Darlene.
Excellent. I believe I was able to put it on the chat here, so you should be able to get it from there.
Yep.
So once again, thank you everybody for joining us today. We're ending a little early, but Pam did such a great job with the presentation. I don't think there's not a lot of questions to ask today. So thank you both, Allison and Pam, and to all of you, have a great afternoon. Take care.
Yeah. Bye-bye.